Hi, I'm Larry Castle here with Ken Brown for episode 90 of That's a Good Question. What about the Supreme Court's draft abortion decision? Just before we started recording this, I was getting concerned about the tongue-tying nature of this week's title. That's a mouthful there,
Yes.
the Supreme Court's decision. We started an episode, a topic last week that we said we were going to finish this week, but we had some very important news break this week.
Right.
So we're going to come back to the Church of Christ denomination next week, but this week we want to take some time and address the things surrounding the leaked Supreme Court opinion to this highly anticipated abortion case that's going on in the court right now. So today we want to answer the question, what about the Supreme Court's draft abortion decision? And there's a lot to cover, so let's jump right in with some background.
Well, this is a huge issue because it involves one of the most important decisions that the Supreme Court will hand down really in our lifetimes. And that's no exaggeration. You know, we hear every presidential election is the most important one in our lifetime and all that, and it's exaggerated. This is really no exaggeration. And it also involves a leak of the decision before it's been finalized, something that's never happens really, and could put the leaker, if the leaker is identified and caught, out of the legal profession altogether, or maybe worse.
I was telling you about just beforehand about something I was reading, and they actually said that there have been leaks, but never of drafts of decisions.
Yeah,
exactly.
exactly.
So that's why this is such a big deal.
I've never heard of anything like this, right?
Yeah.
And so on Monday, that would be May the 2nd, in case someone listens to this a few weeks from now. But Monday evening about 8:30, I'm working on my laptop, and I see notifications coming from news sources about a leaked Supreme Court decision, a decision that will overturn the 1973 Roe versus Wade decision. I wrote to you, I texted you immediately, and we tried to process what was going on. And what was happening was a draft of the court's decision in a highly anticipated abortion case was leaked to the press and released to the public. The draft opinion was for a majority of the 9 Supreme Court justices, 5 of them to be exact, written by Samuel Alito, and it's saying that the court's overturning the 49-year-old Roe versus Wade decision that made abortion a constitutional right. Now, since Monday, we've all learned that the draft is, in fact, authentic. It's real. It was authenticated by the Chief Justice in an announcement that he put out the next day. And so there's heightened anticipation that, indeed, Roe is going to be overturned when the final decision comes out, and that'll probably happen in late June. Okay,
so let's talk first about the leak part of this, get that out of the way, and then we can talk about the decision and what that's going to mean going forward. We hear about leaks all the time in government events and operations. Some bureaucrat talks to a reporter and wants to be kept anonymous because they're not authorized to speak on the topic yet. So does that happen with the Supreme Court as commonly?
No, not at all. This leak is highly unusual. In fact, I think my text to you said highly 3 times. Highly, highly unusual.
Yeah.
I cannot ever remember a leak from the Supreme Court on a decision that's coming out. It points to how high the stakes are then that it happened here. How high the stakes are with this decision and how strongly both sides feel about it, that someone would think leaking this draft would help their side.
Yeah, you mentioned both sides feel strongly, and either side could benefit from leaking the decision, right? In one way or another. So we can basically just guess who's done this, right?
Yeah, and guessing is a favorite pastime in the Beltway in Washington. You know, for decades it was a kind of parlor game in D.C. to identify Deep Throat of Watergate fame, and over the years I heard dozens of names. And for who it was that was feeding information to Woodward and Bernstein when they would write their articles for the Washington Post about Watergate. But when it was finally revealed, Mark Felt was not a name I had ever heard. He turned out to be the number 2 man at the FBI at the time that was going on. And the reason he did it is because he was upset he was not the number 1 man at the FBI. And so nobody had come up with that theory. So the goal of the leaker in this case is Definitely. We do know this, that they are trying to pressure the justices in one direction or another. So a staffer for either a liberal or a conservative justice. Now, I'm saying a staffer because I'm assuming a justice would not do this.
Right.
And I really do assume that.
Yeah.
So a staffer for either a liberal or a conservative justice would have motive to leak it. For a liberal, they want people to know that this is happening before it happens in hopes that public pressure will compel one of the 5 conservatives to change their mind so that it moves from a possible 5-4 one way to a 5-4 the other way. From the conservative side, it would be to pressure the 5 that are named as supporting an overturn to stay with it. Because we know that, and the 5 are Samuel Alito, and then Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Barrett. They've been named as supporting this draft overturning Roe. And if the final decision has them coming out on the other side, then the whole world's going to know that they caved. So it would put pressure on them, presumably that way. So it could have come from either side. Therefore, it's really useless for us to speculate about who did it. The Chief Justice has ordered an investigation to identify the leaker. Whether or not that'll be successful, we'll have to find out.
Yeah. Meanwhile, there's the decision itself, which, as you said, would overturn Roe versus Wade after 49 years of struggle from the pro-life movement to see this happen. So what does it say? Well,
the bottom line is it says Roe was incorrect in its reasoning and conclusion. And so abortion then will no longer be a constitutional right. But rather, instead, as we've been saying for years in the pro-life movement, when and if it's ever overturned, it won't eliminate abortion, and it won't eliminate legal abortion, but it'll turn it back over to the states. Each state will have to determine whether it allows abortion, and if so, under what circumstances.
And it's not, just to clarify, it's not turning it over to state courts, it's turning it over to legislatures.
That's correct.
Which is also for conservative. That's an important point.
That's a very important point, and we'll actually talk about that a bit later as well, yeah. And it arises, the whole thing arose out of a challenge to a Mississippi abortion law that restricts abortion to the first 15 weeks. Now, in Mississippi, this was purposefully written that way to challenge Roe. The hope was that it would indeed get to the Supreme Court and give an opportunity for these now more conservative justices on the court to overturn it if they so chose. It's a challenge to Roe because Roe allows abortion up to 24 weeks. So some thought that possibly the court would uphold the Mississippi law in the 15 weeks, allowing it to be lowered to that, but would keep a right to abortion as something that the Constitution provides. But this decision goes beyond that, and it says there is no right to abortion in the Constitution at any stage. And states then have to determine whether and when a woman can get an abortion.
So if this draft ends up being final, then each state's going to fight it out in their own legislatures, like we were saying earlier, to determine where that state stands on the issue.
And it's already begun in anticipation of the ruling in our own state. Here in Michigan, our governor announced a petition drive to get 425,000 signatures on a petition to have the question put on this November's ballot. And that referendum would be to enshrine in the Michigan Constitution a right to abortion. As it stands right now, Michigan has a law in the books that prohibits abortion. But it's been moot for 49 years because the Supreme Court has said it's a constitutional right, and a constitutional right cannot be abridged by states or anyone. So that law then would become effective again if that leaked ruling is the final one that comes out in several weeks.
So that's interesting because it seems like that's a bad thing to leave a law that is unconstitutional on your state books.
On your books.
Without, don't do anything about it. And then this judgment changes and now it's in effect
now it's
again.
Constitutional.
Seems like they would have had an
Here we
easier
go.
time getting rid of that back when, the tide had turned in the favor of Roe. I don't know.
Yeah, maybe. But, for a long time in most of my adult life, the Michigan legislature, despite overall being a fairly liberal state, our state legislature has been, and if you remember, we had 16 years of a Republican governor. Remember
Right,
John
that's
Engler
true,
as well.
yeah.
And then for a long time, our legislature has been conservative, Republican.
Yeah, that makes sense. So is there any reason to think that the draft that we've seen is not going to match the final?
Not really. I think Roe is going to be overturned in this final version. I don't think any of the five, Alito, Thomas, Gorsuch, Kavanaugh, Barrett, is going to change their mind due to a pressure campaign, which apparently this thing is.
Yeah, I've heard some commentary as well saying that the leak could also be just to change the wording of the draft to try and get it not to be so severe.
Yeah, because this was this was a first draft. This was in February. So whoever leaked this, held on to it apparently. I mean, it's been around. It was a first draft from February, and
Or
those
was maybe
things,
easier to get. That was the other thing the
Maybe.
commentator said.
Okay.
Because it's so old, it might have been easier to get the hands
that could
on.
be. But it's been circulated. That's what happens, and then it gets revised in that process. So maybe it's toned down a bit because that first version, Alito was on fire in that first version for sure.
Yes.
But it has happened before. So I'm saying, I think none of the five are going to change their mind, but it has happened before that a justice has changed his mind, and that happened in an extremely important case. Yes, indeed, an abortion case in 1992, Planned Parenthood versus Casey. Many thought there were enough conservatives on the court to overturn Roe in that decision. But we learned later, after it turned out to be 5-4 to uphold Roe, although modified, that Anthony Kennedy flipped from his initial position to overturn. So it became 5-4 the other way. But it was one that said states can regulate abortion but not eliminate it.
So this could be, if it were one of the more liberal-minded staffers, there could be this sliver of hope that this kind of thing would happen again. But they would need more than one to do that, right?
Well, right now, no, they wouldn't.
Okay.
The only five we know about are the five I mentioned.
Okay.
So John Roberts, the Chief Justice, isn't spoken for right now.
Right.
So we don't know whether we have 5 or 6, so maybe.
Yeah. So why is there all this time between a justice's, you kind of alluded to it, but between their initial position and their final position, so that it's possible, even if very unusual, to be persuaded to the other side?
The way it works is the court hears what are called oral arguments in a case, and they usually take an hour to hear both sides. Sometimes, depending on the nature of the case, if it's something really important, they might make it 2 hours, but usually an hour to hear both sides present their cases orally. Prior to the oral argument, they've already had presented their cases in writing, along with support from other interested parties who submit what are called amicus briefs, Latin for friend. So someone who's friendly to your side presents their reasons for why the case should go one way or the other.
I was going to say, when you said an hour, it seems so brief for such weighty things. It's always a big deal by the time it gets to them, but it's because they've had so much else in writing already.
Exactly. And the truth is the writing is more persuasive than the oral stuff.
Yeah.
Once the written and oral arguments, though, both have been submitted, then the 9 justices meet in private, and they meet that week, and they take an initial vote. And based on that initial vote, the majority assigns one of its members to write the majority opinion, and the minority can assign someone to write a minority opinion. Each of the justices can also write their own independent opinion, but there will be always a majority opinion. But it's the majority opinion then that's the final one. And that's what was leaked this past week. So there's usually a period of months between the submission of the case and its release to the public. And meanwhile, the justices can interact with each other. They can try to persuade one another to flip. Doesn't happen often, but it can, and it has happened. We're now in that in-between period. But in the meantime, that first draft of the majority opinion has been leaked. Hopefully, and as I say, I expect, from my personal standpoint, that the final version will be very much like that draft that was leaked.
Okay. Well, let's talk about some of the controversy surrounding the court overturning a decision that's 49 years old. And then let's talk about what's likely to happen in the aftermath of an overturn of something like Roe versus Wade. So it's quite unusual that a decision is overturned, but it's not unprecedented, right? It's unusual because the court talks about speaking in terms of stare decisis. Are you impressed? I used this Latin term. I had to look it up. Latin for let the decision stand. So why does the court practice that, and why is it being violated now?
Well, the Supreme Court does try to practice stare decisis because they want stability in the law. If the law can be one thing this decade, something else in the next, then people can't order their lives around the law with any kind of confidence. And if the law is a particular way for more than a year or a decade, but in fact for decades, then people have come to rely on it and they've ordered their lives around it accordingly. So this is not something that most of us think about with regard to abortion, but it actually has business and economic impact. Now, as a thoroughly pro-life person, I don't think of it at all in those terms. But the pro-choice people very much do, and I've already heard arguments about what this is going to do economically because of the impact it's going to have on women and the decisions they make. So I'm just using this. I'm not approving of this kind of analysis. I'm just using this as an example. As I say, from a moral standpoint, I think it's horrible to contemplate. But for some people, abortion can be a form of birth control so that there's no so-called interruption. Again, I hate to use that kind of language for a pregnancy. But no interruption to their career, and they and their companies come to count on that.
Yeah.
So one important reason that stare decisis is practiced is to give the law stability, allow people then to rely on that stability.
Yeah.
But it's not inviolable, and it has been breached in the past. Those on the pro-choice side who are decrying this possible violation of stare decisis, they conveniently forget that in just 2003, less than 20 years ago, the liberals on the court did not allow the decision to stand. They did not allow stare decisis when they overturned a 1986 court decision that said states can outlaw sodomy. That was reversed. 17 years later, the court reverses it. Not to mention the famous landmark case, Brown versus Board of Education, 1954, that overturned the Plessy versus Ferguson decision of 1896, and that was the one in 1896 that said you can segregate as long as you have equal, so that you can have separate but equal. And that was the law of the land up until 1954, when the court said separate but equal is inherently unequal. Now, nobody looks to overturn Brown versus Board of Education. And so that has become a super precedent. And then that's actually the term that's being used. Amy Barrett, when she was at her confirmation hearings before the Senate, was asked, the Democrats on the Senate Judiciary Committee asked all of these Republican nominees about Roe. And they wanted to find out where they're going to come out on Roe. We'll talk about that in a little bit. But she was asked about that. And is Roe a super precedent? And she, to her credit, was pretty forthright about that, because she said it's not. It's not a super precedent. Brown versus Board is, because there's no controversy with it. No one speaks against that. But she was saying, no, there's still controversy about Roe.
Right.
And so it's a precedent for sure. And principles of stare decisis need to be applied to it as you think about it. But it's not a so-called super precedent. Now, Alito says in the draft opinion that Roe is not entitled to stare decisis in the sense that it's entitled to analysis in terms of stare decisis, but not to be upheld because of stare decisis. And that's because it was wrong the day it was decided, like Plessy was, because it added a right that's not explicitly in our Constitution and one not otherwise deeply rooted in American law.
Yeah, I read a little bit of it, and he actually gets into like British law, and he left no stone unturned in that.
Right.
So in their confirmation hearings, going back to what you were saying though, in the Senate, the conservative justices have been asked about their views of stare decisis, and they pledge faithfulness to it. But here now they're on the brink of violating it. So what about an accusation that they lied in their confirmation hearings?
And that accusation's been made that you perjured yourself.
Yeah.
And I understand why it's made. Now, Barrett didn't. She was quite forthright. This is not a super precedent. I thought she explained it, frankly, better than the other two, better than Kavanaugh did, better than Gorsuch, especially better than Gorsuch did, because he actually was asked, so, Roe is the law of the land, and you agree with, don't hold me to that, agree with, or you, concur, something to that effect. And he says, yes, that's the law of the, it's the law of the land. Well, one could be forgiven for walking away from that, saying, okay, he understands Roe is, is
He didn't
settled.
say super precedent, but
He didn't, and he didn't say he wouldn't overturn it. He didn't make any commitments like that.
Yeah.
But since Robert Bork, going back to the 80s, and he became a verb, as we've talked about before. Someone gets borked, because that was the first time really that you had a Supreme Court nominee, and then you had all of these political forces arrayed against him, and it became quite a circus. But one of the things that Bork did was Bork made the mistake, and I say the mistake kind of tongue-in-cheek, of telling the truth. I mean, he just said, they asked him, what do you think about Roe? And he says, Roe was clearly, wrongly decided. And here he is as an academic, and he knows all kinds of other academics who think the same thing, even people who are pro-choice.
Right.
Believe that it was wrongly decided, that the reasoning was wrong. And so he's just saying what a lot of people already know, but he's also saying, if I'm on the court and I have the opportunity, I would vote to overturn it, which is not what, the Democrats on the
you're
committee want to hear.
prejudging. It's not before you yet. So.
And okay, so he since that time, telling what you would just actually do has become verboten. You don't do it. So a few years later, none other than Ruth Bader Ginsburg.
That doesn't stop the Senate from asking.
Totally. And they can't get anywhere. Exactly. It's a little
crazy to
dance that
watch.
they do.
Yes,
it is crazy to
yes.
watch. So here's Ruth Bader Ginsburg, nominated by Bill Clinton, I think 1993. And she created what has come to be known as the Ginsburg Rule, saying that she could not comment on something that might come before the court. Well, that's allowed conservatives then to now say the same thing regarding Roe. And regarding stare decisis, they've then done that kind of kabuki dance, and tiptoed. In
Now
some
I've got
cases.
another word to look up, kabuki, note to self.
And in some cases, they will say, doing the dance, that it's important and Roe is entitled to respect in that regard. But no one actually pledged that they would not overturn it or made any explicit promise on how they would rule. They used terms like it's settled law. But if you think about it, I mean, if it's settled bad law, then what are you going to do? But I do understand why those on the other side are upset, because they did indeed say, as I said, they tiptoed around it. Not to mention how some of these justices who are now poised to overturn Roe got on the court in the first place. The Democrats are steaming mad about that. I mean, remember, in February of 2016, we're in an election campaign, and Antonin Scalia has a heart attack, while Barack Obama still has 11 months left as the president. So what's supposed to happen? Obama will get to choose who's going to replace a conservative stalwart like Antonin Scalia. Well, that didn't happen. Remember, those that a president selects have to be confirmed by the Senate, and the Republicans control the Senate. And the leader of the Republicans in the Senate, Mitch McConnell, said, we're going to let the next president choose the successor, since there's an election in November. And he actually said this, and Republicans said this at the time. They're like, how can you do that? Obama's the president. He's still got a long while left in his presidency. It's not like it's next month, the election. And they said, well, Joe Biden, when he was a senator, he advocated for not having anyone put on the court when you're close to an election. So they called it the Biden rule, and they just, with great glee, they're putting this on Biden. Now, Biden, in that so-called Biden rule, there is a speech of him saying, we're too close to an election. I think he was making that speech in like July or something. So it wasn't 9 months out still. But the Republicans used that, and lo and behold, Trump wins. And so who gets to replace Scalia? It's Trump, and he does so with Neil Gorsuch. Then Anthony Kennedy retires during Trump's time. Trump appoints Brett Kavanaugh, and a Republican Senate confirms him. But then the killer, if you're a Democrat, Ruth Bader Ginsburg dies September of 2020, an election year. She dies less than 2 months before an election. And Mitch McConnell and the Republicans suddenly forgot that 4 years earlier they were touting the so-called Biden rule.
You say forgot with quotes,
yes,
right?
exactly.
Okay.
And they were and remember, they were touting the Biden rule and saying, we'll let the next president decide. No, they rammed through Amy Coney Barrett in record time, and she was on the court the following month.
Yeah.
And so I understand why the Democrats are upset with the shifting standards. I'm personally pleased with the outcome, though I don't approve of making up standards as you go for political expediency.
Well, we've set the precedent, speaking of precedent, for the other side to do that to
That's
us.
right, exactly.
Yeah.
Oh, it's,
We've
yeah.
made our bed. We're going to have to lie in it,
Yep.
perhaps.
Yeah.
Yeah. So here we are then on the verge of having Roe overturned, and it appears that it will be with the votes of 3 appointees put on the court by Trump,
Yeah.
Gorsuch, Kavanaugh, and Barrett. So we've been pretty hard on Trump here for his lack of character for the last 7 years.
Yeah.
But we at least have to give him credit for this, right?
Yes. The people that hear me criticize Trump don't remember that I've always said that the best thing he did was his court picks. And the best thing he did in his campaign in 16, and I said it in 16, actually, we didn't have this podcast back then, but I said it in 16, was that he did this brilliant thing, his campaign did this brilliant thing of publishing a list of candidates from which he would choose for the Supreme Court. No one else had done that I can ever remember. And he had about 22 or 24 names on there, and Gorsuch and Kavanaugh, these are the people that run it. And so to his credit, when he was elected, he did that. He chose from that very list.
And so that alone makes it worth having had Trump as president and, becoming connected at the hip as evangelicals with him, right?
Not so fast. Okay, I give credit where credit's due, but not so fast. I think that other Republicans, frankly, would have done the same. People look at...
Could have done the same.
They could have done it, and I think they would have.
Okay.
I mean, I don't know, obviously, but I think they would.
I make that distinction because I've just struggled to remain confident in Republicans in the last several years. But I see what you're saying.
Here's
yes.
why I have that confidence, though, okay? Trump and they would have had, if a Republican won in 2016, and if it was someone other than Trump, they would have had two advantages, like Trump did, that other Republicans prior have not had. And that's one of the reasons I think we've been disappointed, is because they didn't have these advantages all the time.
Yeah.
He had two things going for him. He had a Republican Senate the entire 4 years that he was president. And then to have three people, to have three picks in a 1 4-year term, that's unheard of.
Yeah.
You go all the way back to Nixon since someone had that opportunity. But he had a Republican Senate, so he could get his judges through. So he could pick people that were more conservative, because the Republicans could get them through,
yeah.
right? And he had the benefit of this very deep bench of people to choose from, created by something called the Federalist Society. The Federalist Society started in 1982. So when Reagan and then his vice president became president, George H.W. Bush, that was a fledgling organization. And they were training conservative lawyers and judges, originalists and textualists. But you didn't have that deep bench. The reason Reagan chose a guy like Robert Bork is he was one of the few guys out there that was an outspoken originalist at the time. In the mid-'80s, you just didn't have that. Now, by the time you get into the 2000s with George W. Bush, he still had less. He has a deeper bench, but still less than Trump did. Trump now has, with the Federalist Society and now a Republican Senate, he has got everything that none of these predecessors ever had. So, and consider this, that 2 of the 5 who are now poised to overturn Roe were put on the court by George H.W. Bush and his son. Clarence Thomas by George H.W. Bush.
Yeah.
And Samuel Alito, who wrote this majority opinion, was by George W. Bush.
That's really helpful additional information, because some of that I wasn't aware of, and that is helpful.
And maybe 3, because it might be a 6-3. Right now you've got 5 that are said to be on the side of overturning. We don't know where John Roberts is, the Chief Justice, and he was appointed to the court by George W. Bush. So it might be 3 of 6, or it might be 2 of 5. So that's why I say I have no doubt that another Bush, if Jeb had won, he would have done likewise. And because we would have had a Republican Senate for 4 years, and he would have had this deep bench.
All without selling our birthright.
Well, there you go. And that's again my plea that we've been making for a very long time. Listen, win at all costs is problematic for Christians. is because it says something about, if you look at it and you say, look, Trump did this, and so it was worth all of the getting connected at the hip, like you said.
I've seen several people posting Trump 2024 tagged on to their glee about this decision.
Okay,
Yeah.
so this shows that. Look, one, how do you know? Now, I don't know that Jeb Bush would have done. I don't know that. I gave the reasons why I believe that would be the case. But even if that is not the case, are we saying that God cannot get done what he wants to accomplish by us simply operating on principle? That I want to avoid associating myself with a lack of character. I don't want to get attached. So we've said, look, if you're faced with two choices in a vote, you vote for the lesser of two evils. We most of the time have to do that. And so I understand people vote. I voted for Trump in 2016, holding my nose the whole time, but I did it. But what have we said? We've said vote, but don't promote because of the whole character thing. And if I dearly wish that we had had a different option at that time. Now, what would have happened? I don't know for sure. But I can trust God with that, can I? Mm-hmm. We don't need to cut corners and take matters in our own hands. We can simply say, Lord, I'm doing what I think is in accord with the principles that you've laid out. And so now take this and use it for good. Yeah. Having said all that, I do give Trump credit for appointing who he said he would appoint.
Well, if things go as the leaked draft indicates, and there are at least 5 votes to overturn Roe, then you'll look like a prophet. Because back in December, just after the court heard oral arguments in the Mississippi case that it's now deciding, I remember you said on this podcast, I think they have 5 votes to overturn Roe.
Okay.
So, Nostradamus, what happens from here?
Nice. Well, first, lots of observers were predicting an overturning of Roe, so it's not actually that impressive. But
Let me be impressed.
Okay.
All right.
So as far as what the aftermath's going to be, well, states are going to fight it out, as we've already said. Republicans now, though, are going to have to stand up and be counted. And I just say to our listeners, keep a close eye on this. Keep a close eye on what happens now with Republican politicians who have said they're pro-life. Because I have a belief that a lot of the people who say they're pro-life aren't. And they're able to say they're pro-life because it didn't mean anything. Because you could be a Republican politician, say you're pro-life, and you're for overturning, Roe, all the while knowing it's not going to happen.
You never have to cast a vote on the issue.
Now you have to cast a vote.
Yeah.
Now you have to stand up and be counted, and that's going to be an very interesting thing to watch. But another very interesting thing to watch is with the reasoning that Samuel Alito is using in that majority opinion. A lot of times with the Supreme Court, what's more important than the decision is the reasoning in the decision. Because the reasoning is used in later decisions. The subsequent cases, they will cite the reasoning in previous cases.
That's where when we talk about precedent, it's not the decision, it's the way the decision was arrived at.
And he has got this reasoning in there that has implications for other issues, other big cultural issues. Just 7 years ago, we had the decision on the same-sex marriage case. These are all privacy issues. And that's how the court has looked at them since Roe and just prior to Roe. Remember that Roe relied on a case, Roe versus Wade, 1973, relied on a case from 1965 called Griswold versus Connecticut. And it was that Griswold case that has the infamous phrase, Penumbras formed by emanations from the Bill of Rights. Okay.
Which justice was making fun of that?
It was, it's Clarence Thomas. Clarence Thomas has reportedly, he has on his desk a little plaque that says, please do not emanate on my penumbras. Penumbras, shadows emanating, derived from. So shadows derived from the Bill of Rights. I mean, that's what that is saying. That the right to privacy is not in the Constitution explicitly, but it's derived from shadows that come from the First Amendment, the Bill of Rights. Okay, now we conservatives, we make fun of that, and I think rightly so, because you're making up rights that aren't in the Constitution. But when we say they're not in the Constitution, this is a real debate, and it's a real issue, that not everything that we have a right of is explicitly stated in the Constitution. As a matter of fact, the Constitution actually says as much. The Ninth Amendment says this: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Other rights
Other rights retained by the people.
that we didn't list.
Exactly. So there are unlisted rights. Well, okay, that raises a question. What are those unenumerated rights? And that's a real question. So being an originalist doesn't tell you that automatically. You know, and so we can say, guys like me can say, hey, there's no right to privacy in the Constitution. Well, okay, but is there a right to privacy that people have that it's not enumerated?
Yeah. Well, and that's important to have the discussion that way, rather than claiming it
There
comes
you
from the
go.
Constitution. Say, well, no, it's not in the Constitution, but we still believe it should be a right.
And really here's the thing: who should decide that?
Not the courts.
Okay.
They don't make laws.
Exactly. And so
Yeah.
now what's happening is it's going back to the political branches,
Right.
and we as a culture in the public square are going to have to debate this, and we're going to have to decide, is same-sex marriage something that is good for society and that the state has a compelling interest in promoting or in not promoting, you know? So we have to debate that.
This highlights the beautiful nature of our system.
I think
by
so.
the way, these separations of powers and the way it's.
But when judges make the decision, it takes that out of the hands
Yeah.
of the people.
Yeah.
Now, the way that's been done by those who find these rights, okay, and judges who find, how do judges do it? Well, where do they find it in the Constitution then? You know, how do they determine these unenumerated rights? Well, one important way it's been done is through something called substantive due process. Say what? And that's what's used in, like, the Obergefell, that's the same-sex marriage case in 2015. And it comes from our 14th Amendment that says no state shall deprive any person of life, liberty, or property without due process of law. Now, I heard Antonin Scalia many a time talk about this substantive due process idea, and he hated it. And the reason he hated it is because it's based on what I just read. And he says, look, due process is procedure. It's saying that you can't deprive anybody of any of these unless they've had access to the legal process.
Right.
Okay?
Right.
That's what he's saying. But so what is substantive due process as opposed to procedural due process? Well, those who advocate for it say it includes liberties that are not explicitly mentioned in the Constitution. And among those, then, is the right to define your own view of life and existence. And I'm not making any of that up. That's language from Anthony Kennedy.
Yeah, I think we've referred to this in
We
the
have.
past. Yeah.
So here's Scalia's blistering dissent in the 2015 same-sex marriage case, okay? And I'm going to read it at some length, but it is just blistering. And it's kind of funny as well, as Scalia was wont to be. But he says this court, he's addressing the question of who gets to decide. And he hated the fact that here we have this monumental question going on about marriage, and we got 9 people trying to decide this. So he says this court, which consists of only 9 men and women, all of them successful lawyers who studied at Harvard or Yale Law School. 4 of the 9 are natives of New York City. 8 of them grew up in East and West Coast states. Only 1 hails from the vast expanse in between. Not a single Southwesterner, or even, to tell the truth, he says a genuine Westerner, because California does not count. He says, not a single, he says, evangelical Christian, a group that comprises about 1/4 of Americans, or even a Protestant of any denomination. The actual outcome of the case, getting gays to marry, is not, he says, of immense personal importance to me, but it is of overwhelming importance who it is that rules me. Today's decree says that my ruler and the ruler of 320 million Americans coast to coast is a majority of 9 lawyers on the Supreme Court. The opinion in these cases is the furthest extension, in fact, and the furthest extension one can even imagine of the court's claimed power to create liberties that the Constitution and its amendments neglect to mention. This practice of constitutional revision by an unelected committee of 9, always accompanied, as it is today, by extravagant praise of liberty, robs the people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, namely the freedom to govern themselves.
Wow.
And he's going on. No, he goes on, quoting Kennedy, Anthony Kennedy, who wrote the majority opinion in that same-sex case in 2015. He says, this is Kennedy, "The nature of marriage is that through its enduring bond, two persons together can find other freedoms, such as expression, intimacy, and spirituality." And here's Scalia, in parentheses, this is in his opinion, in parentheses, he says, really? He says, "Whoever thought that intimacy and spirituality, whatever that means, were freedoms? And if intimacy is one would think freedom of intimacy is abridged rather than expanded by marriage." And he says, showing his age, "Ask the nearest hippie."
Oh, wow.
And what he's saying is, the guy doesn't get married because he knows that marriage restricts, your ability to play around. And then he goes on, he says, "Rights," Scalia says, "we are told can, quote, rise from a better informed understanding of how constitutional imperatives define a liberty that remains urgent in our own era." Again, in parentheses, he says, huh? How can a better informed understanding of how constitutional imperatives, whatever that means, define, whatever that means, an urgent liberty, he says, never mind, give birth to a right? I mean, he's on a roll here. He says, this is how he ends it, even as the price to be paid for a fifth vote. He's saying that I'll be willing to join with you that there was some horse trading on this decision.
Okay.
And I will be the fifth vote if you will say it this way and take this approach. If, even as the price to be paid for a fifth vote, I ever joined an opinion for the court that began, quote, "The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity," he says, "I would hide my head in a bag." The Supreme Court of the United States has descended from the disciplined legal reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie.
Wow.
He says the world does not expect, I'm almost done, logic and precision in poetry or inspirational pop philosophy. It demands them in law. This decision has diminished this court's reputation for clear thinking and sober analysis. Hubris is sometimes defined as overweening pride, and pride, we know, goeth before a fall. So that's what he says. And I bring all that up because that fight, that's been just percolating. I mean, that's been boiling. Mm-hmm. He's gone now. But Alito, the reason Alito's on fire is because of this. Mm-hmm. And what the fallout of this is going to be, I think, is going to be now challenges to some of these other things that are non-enumerated rights that have come from substantive due process. You see what I mean?
Yeah. I mean, it's just lowering the burden of what can pass.
Good way to put it.
When you do that, it's just a free-for-all.
Two more things and I'm done.
Yeah.
But so what's going to happen now going forward? Here's what I'm afraid of, guys, listeners. The reason for 5 years, 7 years, we've been saying, distance yourself from people who will harm your credibility as a Christian, is because if we want to be players in the public square, and I think Christian voices should be heard in the public square, I'm happy to use whatever forum I can for that, and we ought to try to influence for good legislation and what's happening in our society. But you've got to have credibility. And if you lose that credibility, now here we are, having, I think, harmed our credibility greatly. And we're going to impose stuff. Now, I think we're justified in those impositions. But when you're imposing things on people, then credibility matters all the more. You know, that people know that you're coming from a place of true conviction. And that those convictions don't shift in order to win.
Right.
And that's what, and I'm afraid.
You can't complain. You can't make your case that you're all about truth when you're willing to cave on it over here to get your way.
Exactly. And I'm afraid, okay, here we are.
Mm-hmm.
Okay, this is going to happen. And I celebrate that. I do. But I'm afraid that loss of credibility as we impose and we move toward imposing on other things possibly, if the substantive due process idea is challenged more, you see what I mean, all right?
Yeah.
Last thing is that Christians need to be, as I said in our State of the Church address back in January, and I've written on our blog, that Christians need to be pro-life. We need to be pro all of life. And especially now, because if we are going to have laws that say you can't get an abortion, you're going to have that child, then I think it's incumbent upon Christian people to be willing to step up and help in every way we can. So crisis pregnancy center, that kind of thing.
You know, I had a couple conversations online with people I'm connected with on Twitter this week, and when you say that kind of thing, conservative people from our camp immediately read it as, we can't do this if we're not willing to. And they say, well, why do you have to do this in order for this, to somehow prove it's wrong to kill a baby, for example? Right. That's not what we're saying at all.
No.
The first is right, should be done no matter what.
Correct.
Now that it's done, here's our opportunity / responsibility.
And what does wisdom dictate? We do.
Yeah.
Aren't we supposed to live as wise people? Doesn't the Bible?
I said more than one time in that conversation, we're to be wise as serpents, gentle as doves.
Exactly.
Yeah.
Yep.
Well, I hope this conversation was helpful to you. This is going to be in the news for a while still. You're probably going to have occasion to talk about it, be asked about it, and we hope this helps you. Want to remind you, if you don't already, subscribe to our YouTube channel, hit the notification bell so that you know when new episodes come out. We try to do those every Saturday at 2, and we look forward to seeing you in the next one. If you have a question you'd like us to consider, you can send that in to our email address, info@cbctrenton.com, or text it to us at 97000.